Rule 101. Rule 101. Scope. These rules govern proceedings in all courts in the state of Colorado to the extent and with the exception stated in Rule 1101. This is Article 1, General Provisions of the Colorado Rules of Evidence, CRE 101. Scope. These rules govern proceedings in all courts in the state of Colorado to the extent and with the exception stated in Rule 1101. Rule 102. Purpose and construction. Purpose and construction. These rules shall be construed to secure fairness in administration and elimination of unjustifiable expense and delay and the promotion of growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. One more time. Scope. These rules govern proceedings in all courts in the state of Colorado to the extent with the exception stated in 1101. These rules, 102, shall be construed to secure fairness in administration. Fairness. Fairness. That's law. Elimination in administration. Elimination of unjustifiable expense and delay in the promotion of growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. So there's four things there? Four purposes. Fairness and administration, elimination of unjustifiable expense and delay. Number 3, promotion of growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. So 3 main purposes. Rule 103, rulings on evidence. A, effect on erroneous ruling. Error may not be predicated upon a ruling which admits or excludes evidence unless a substantial right of the party is affected. And number 1, objection. In case the ruling is one admitting evidence, a timely objection or motion to strike appears of record stating the specific ground of objection if the specific ground was not apparent from the context. Or 2, offer of proof. In case the ruling is one excluding evidence, the substance of the evidence was made known to the court by offer or was apparent from the context within which questions were asked. Once the court makes a definitive ruling on the record admitting or excluding evidence, either at or before trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. B, record of offer and ruling. The court may add any other or further statement which shows the character of evidence, the form in which it was offered, the objection made, and the ruling thereon. It may direct the making of an offer in question and answer form. C, hearing of jury in jury cases. Proceedings shall be conducted to the extent practicable so that as to prevent inadmissible evidence from being suggested to the jury by any means, such as making statements or offers of proof or asking questions in the hearing of the jury. D, plain error. Nothing in this rule precludes taking notice of plain errors affecting substantial rights, although they were not brought to the attention of the court. Rule 104, preliminary questions. A, questions of admissibility generally. Preliminary questions concerning the qualification of a person to be a witness, the existence of a privilege, or the admissibility of evidence shall be determined by the court, subject to the provisions of subdivision B. In making its determination, it is not bound by the rules of evidence except those with respect to privileges. B, relevancy conditioned on fact. When the relevancy of evidence depends upon the fulfillment of a condition of fact, the court shall admit it upon or subject to the introduction of evidence sufficient to support a finding of the fulfillment of the condition. C, hearing of jury. Hearings on the admissibility of confessions shall, in all cases, be conducted. C, hearing of jury. Hearings on the admissibility of confessions shall, in all cases, be conducted out of the hearing of the jury. Hearings on other preliminary matters shall be so conducted when the interest of justice require or when an accused is a witness, if he so request. D. Testimony by accused. The accused does not, by testifying upon a preliminary matter, subject himself to cross-examination as to other issues in the case. E. Weight and credibility. This rule does not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. Rule 105. Limited admissibility. When evidence which is admissible as to one party or for one purpose but not admissible as to another party for another purpose is admitted, the court, upon request, shall restrict the evidence to its proper scope and instruct the jury accordingly. Rule 106. Remainder of or related writings or recorded statements. When a writing or recorded statement or part thereof is introduced by a party, an adverse party may require him at that time to introduce any other part or any other writing or recorded statement which ought in fairness to be considered contemporaneously with it. And those are the 100s. Now, CRE 201, Judicial Notice of Adjudicative Facts. Article 2, Judicial Notice. Rule 201, Judicial Notice of Adjudicative Facts. Scope of rule. We'll get back to the 200s. That's pretty much all we got. 100s, 200s, 300s. And here's that famous 1101. The big famous 1101. Making and responding to common objections. Objection. Like to preserve the error for appeal. Objection. I like to preserve the error for appeal.